We don't have a smart board for this particular lecture, but what I'd like for you to do is print off the PowerPoint notes for the chapter on the judiciary, and we'll start with slide number 8, okay? Slide number 8, and it'll talk about the origins, okay? Our judicial system in the United States comes to us from England, and in England they have a common law system, and so do we in the United States. And this common law system is the idea of trying to keep court decisions consistent throughout the country, okay? So as you look at slide number 8, you see a couple of terms, precedent and stare decisis. The idea behind these two is to keep our decisions, judicial decisions, consistent throughout the country. So precedent is the idea of if a judge has ruled one way in a particular case that's similar to yours, you can expect that judge to rule very similar to the judges in the past have ruled. And then stare decisis is a term meaning let the decision stand. The idea of relying on precedent, cases that have already been decided to make a decision in the current case. Okay, so as we move on to slide number 9, sources of American law, okay? Where do our laws come from, okay? They come from constitutions, statutes, and administrative regulations, and case law. Now, the constitutions themselves, lawyers and judges will look at the U.S. Constitution and that particular state's constitution, in our case, Missouri. And so they'll look and make sure that does the Constitution of the United States say anything about the case, or does the Missouri Constitution say anything? If it doesn't, then they look at statutes. Statutes are laws made by a legislative body. For example, the Missouri State Legislature would make statutory law, statutes. Okay? So, a statute is a law made by a legislative body. So what does the state legislature of Missouri say about this situation? Okay. We also have on slide 9 administrative regulations. These are laws made by an executive agency. In the case of the federal government, we had what's called the Code of Federal Regulations, where executive agencies' rules are published. Last, we have case law, laws that are made by a court. A good example of case law is Brown versus the Board of Education, where the Supreme Court ruled that public schools can no longer be segregated on account of race. So case law are laws made by a court. Okay, moving on to slide 10. The United States has a dual court system, which means that we have a state court system and a federal court system. Okay, most of our energy and the book is going to be spent on looking at the federal system. Okay, so basic judicial requirements for the federal system are: number 1, does a particular court have jurisdiction? Do they have the right to hear that particular case? Okay, that's the first thing a federal court has to keep in mind. So then they look at, does a particular case involve a federal question, such as a law made by Congress, interpretation of the U.S. Constitution, or the Code of Federal Regulations. Now, another type of case that makes its way into the federal court system is what's called diversity of citizenship. This is where you have two people or more, where you have people who are from different states and the amount is over $75,000. For example, you have a car wreck between a resident of Missouri and a resident of Tennessee, and the amount of damages is more than $75,000. The case will be held in federal court. A lot of times in federal court, you'll have people suing truck driving companies who may be registered in Rhode Island while they may be a resident of Missouri. So you have that diversity of citizenship. Then lastly on slide 10, do they have the standing to sue? Are they the right party to be suing in this case? Now, as we move on to slide 11, the parties to a case. The plaintiff is the person who initiates the lawsuit. The defendant is the person who has to respond, or the person who has allegedly committed some wrongdoing. Okay? Now, in federal courts, there can be more than one plaintiff or more than one defendant. Sometimes you'll see the abbreviations ET.AL. That means other plaintiffs or other defendants. Okay, now, as we look on slide 11, class action lawsuits, okay, these are for situations when you may have a lot of people who may be affected by a particular instance. We see a lot of commercials on TV about, have you taken this drug and had a liver problem or something like that. Those are class action lawsuits because there are a lot of people who could be affected by a potential bad drug or potential bad medicine. Okay, now you see the term amicus curiae briefs, okay? These are arguments sent to a court by non-participants in the case in support of a particular position, okay? So these are folks who are not involved in the case but want the courts to know what they think about the issue. Okay, as we move on to slide 12, the procedurals, okay? The most important thing when it comes to procedures, we have these procedures in order to make sure everyone gets a fair trial. And so that's why we have very specific rules, procedures, and deadlines. So to make sure everybody gets a fair trial and the litigation proceeds in an orderly manner. The parties must also comply with what the judge wants them to do. So if the judge says, you have 30 days to turn over a particular piece of evidence, you have to turn it over within 30 days or it could jeopardize your case. Okay, now we look at the actual courts in the United States. Slide number 13. Okay, the first type of court is the U.S. District Court. Okay, these are trial courts. Most of the trials at the federal level are held here at the district court level. You have a jury, you have lawyers, you have witnesses, and the jury makes a decision. Okay, these are trial courts where the trial is held. Okay, and they're courts of general jurisdiction, which means they can hold a lawsuit and hear a lawsuit for just about any type of case. If you look on page 281 in your book, you'll see a chart where it talks about, you'll see the chart and it mentions lots of courts. Some of them are very specific, like a tax court, bankruptcy court. Those are very specific courts, and they don't hear nearly the amount of cases that the district court would. Okay? Now, Court of Appeals is the second level. If you're not happy with the decision you get at the district level, you appeal to the U.S. Court of Appeals. This is a much different situation. There's no jury, there are no witnesses, no testimony, and what happens is the lawyers of both sides argue to a panel of 3 to 5 judges, and they look at questions of law, not necessarily the facts of a case. Instead of deciding guilt or innocence, they may look at, did the judge make an error in allowing evidence to be admitted or to not be admitted? That's what they're looking for. They're not looking at guilt or innocence. They're looking, did the judge follow proper procedure? Was the judge fair? That's what they're looking for, not necessarily facts of the case. Okay? Now, the final court is the U.S. Supreme Court. And it can be a court of original jurisdiction, a court where the trial is held, or appellate jurisdiction. And so they look at, they can hold trials and hold appeals as well, okay? And so they can hear appeals from the U.S. appeals courts, or they can hear appeals from state courts if a federal question is involved. Most of the time this situation occurs if it's more likely to affect a lot of people. And so sometimes that occurs. Another good example of cases coming from a state Supreme Court that goes directly to the U.S. Supreme Court are death penalty cases. The people who are about to be put to death may make the argument about cruel and unusual punishment is forbidden to try and get a stay of execution. Okay? Now the Supreme Court, how is it run? It sets up on an annual term. We're looking at slide 16 here. Okay? It begins its annual term the first Monday in October. They hear cases that will have a significant impact on the country as a whole. Okay? And they can exercise a large amount of discretion in what type of cases they want to hear. Realistically, you've got maybe a 1% to 2% chance of the Supreme Court hearing your case, and that's at best. So the Supreme Court can decide what cases they want to hear, and most of them have national significance. Last month, the Supreme Court made a ruling on the Westboro Baptist Church in Topeka, Kansas. And so because that was a free speech issue, that's why the Supreme Court took that up and made the decision that they did. Okay? So, what are some of the factors on slide 17 that bear on the decision? Okay? They're going to look for, have lower courts ruled differently? Has a district court in Georgia ruled differently from a district court in Missouri? That's something they may want to clear up if lower courts are ruling differently. Or if the lower court makes a ruling that goes against what the Supreme Court has said in the past. If there's pressure from the Solicitor General. The Solicitor General is kind of what we think of as the top attorney in the United States. And if the Solicitor General wants a case to be heard, the Supreme Court takes that into serious consideration. And then what they'll also look at, we're on slide 17, does the issue have broad significance beyond the parties to dispute? Will this affect a lot of Americans? Or will this affect a lot of folks all over the country? And so they keep that in mind. Okay, now, how do they decide which cases? Okay, slide 18. You have to keep in mind most petitions to be reviewed are denied. Okay, if the court wants to hear a case, 4 of the 9 judges must agree to hear it. And if they do agree to hear it, they will issue what is called a writ of certiorari. And a writ of certiorari is this idea that the lower courts that have heard the case in the past will have to turn over all of their documents and testimony to the Supreme Court, and they will look at all of it. Okay? So it's quite a laborious process of writ of certiorari. Okay? So the court will order, all lower courts to turn over documents and testimony, things like that. Now, on slide 20, once the court has actually made a decision, it will publish its opinion to the public. Okay? A case can be affirmed. Affirmed means they agree with the Court of Appeals. A reverse decision on slide 20 means they disagree with what the appeals court said and they've changed the decision. Or it's more likely to be remanded. Remanded means they send it back for a new trial with certain conditions. They may say, we remand this back to district court and certain evidence must be included or excluded. Remanded means you have to start the trial process all over again with certain conditions. Okay? Now, an opinion explains the court's decisions. This is slide 21. A unanimous opinion is when all 9 justices of the U.S. Supreme Court agree. But that's not always the case. Sometimes you have what's called a majority of opinion, where you may have 5 out of the 9 agreeing, and that changes the situation. Okay, and the majority opinion is most judges deciding one particular way. You could have what's called a concurring opinion, where they agree with the outcome of the majority on the case, but for different reasons. Then last you have the dissenting opinion. A dissenting opinion is written by a judge or judges who disagree with the majority. And a lot of times, dissenting opinions written by a couple of judges may be the foundation for a case in the future to make an argument for, okay? Now, sorry about that, slide number 22. The President of the United States appoints the judges at all levels, okay? The district court, bankruptcy court, tax courts. The President appoints them and the Senate must confirm them. Okay? All they need is a simple majority of the Senate to confirm them. And so the Senate has a special committee, okay? And it's called the Judicial Committee within the Senate, or the Senate Judiciary Committee, as you may hear on TV. This is where they screen the potential judges, because these judges basically serve lifetime terms. So this Senate Judiciary Committee is going to screen them, and they're going to ask them all sorts of questions. You wrote an article about a particular case. Why did you write that article? Is your opinion the same today as it was when you wrote that article? So they find out, they do a lot of searching about these judges because they stay in office basically for life until they quit, are kicked out of office, or die. Okay? And so federal judges on slide 23 serve until they retire, die, or resign from office. Okay? Judges may be removed and impeached from office. So remember we talked about that when it came to removing the president. Federal judges can be impeached if they're engaging in bad behavior such as bribery or always ruling in favor of one particular attorney. Things like that can get them removed. Okay, slide number 24, federal district court nominees. Okay, at the district court, you have this idea of senatorial courtesy. If the senior senator from a particular state where there's an opening likes that judge, then they typically allow that senior senator to allow that person who's going to be judged to go on through and then go straight to the Senate Judiciary Committee. Okay, and so then at the Court of Appeals, these can be much more political because the Court of Appeals is a very important and often the final decision maker in a lot of cases. They go through a lot more scrutiny. And so judges at this level get a lot more intense screening by the Senate Judiciary Committee than a judge at the district court level. Okay? Now, slide number 25. The background of most Supreme Court judges and most federal judges is they have a background in legal practice or they've been a judge at some level. Okay, that's the background behind it. Now let's go ahead and move forward to slide 27, the presidency and the courts. Okay, presidents often view their judicial appointments as a way to institutionalize their legacy once they've left office. Sometimes this can be good, sometimes it can be bad. President Eisenhower said that one of his appointments, Earl Warren, was the worst decision he ever made as president by appointing Earl Warren to the Supreme Court. Okay, so sometimes it can be a negative effect. And then keep in mind that presidents who serve 2 full terms end up appointing a lot of members of the judiciary. They end up appointing a lot of federal judges at the appeals court, the Supreme Court level, and even the district court. So a 2-term president can really have an impact on the Supreme Court if vacancies or openings occur. Okay? Now, on slide number 28, the Senate is kind of neat in their role. They confirm the judges. Okay? Just a majority of the Senate has to confirm the judges. But they've had periods throughout their history where they may not deny a judge appointment for years, or they may go through a period where they deny a lot of judges seats at the appeals district or Supreme Court. It just depends on their history. Okay? Now, slide number 29 talks about the court's power. They have the power of judicial review, which comes to us from the court case Marbury v. Madison. And it says, judicial review allows the court to examine the actions of the president, the office of the president, and Congress. So if they pass a law that might be unconstitutional, the Supreme Court can rule and say this law is unconstitutional. Judicial review on slide 29 simply is the right to review the actions of the President and Congress and determine if their actions fit within the guidelines of the Constitution. Okay? Something to keep in mind here. The higher level of federal court the decision comes from, the greater impact of the decision on all society. Here's what I mean by that. When the U.S. Supreme Court makes a ruling, it applies to everybody in the United States. Okay? So since it's the highest court in the land, it applies to everyone. Okay? Now we take a look at slide 30. We're going to look at some ways people try to classify judges and their behavior. As you can see on this slide, we have judicial activism, judicial restraint, strict constructionist, or broad constructionist. Judicial activism is this idea that federal judges and other judges should use their power to closely monitor the laws passed by Congress or the President. Okay? They keep an active check on our elected officials. Whereas judicial restraint, they're much more passive. Okay? They tend to defer to the elected officials to, and what decision those elected officials make as opposed to what the judge might say. So they defer to the elected officials, whereas judicial activism, they keep much more of a check on the decisions of the president and the courts. Now, a strict constructionist and a broad constructionist. A strict constructionist is a judge who tends to look at the laws in a literal sense. You know, they look at the laws in a literal sense, word for word, what do they mean? There are other judges, broad constructionists, who look at the Constitution and other laws as open to being changed, open to being re-examined and look at, you know, how does this apply in modern standards to a law that may have been written 100 years ago or so. Okay, so the Supreme Court today on slide 31, the court is tending to be much more conservative in its rulings because we've had George W. Bush got to appoint 3 of the 9 federal judges, and there were already judges on the Supreme Court who were conservative to begin with before the Bush administration's appointments, okay? And many of the cases on our Supreme Court may be closely divided, like 5-4 decisions. But the court has taken a much more conservative stance, and also their rulings are much more narrower in scope. As opposed to 20 years ago, the rulings were much more broader for all of society, okay? Now, are there ways, if we go ahead and move forward to slide 33, are there ways the legislature and the president can check the courts? Yes, there are. The president can check the courts by making appointments to the bench. If he doesn't like some of the rulings, he can pick someone who might rule differently. Okay, so that's one way the president can do that. Then the president is also responsible for implementing these new changes. So the president, in its authority to implement the changes, may be able to make some minor subtle differences in what the court intended. Now, the legislative branch or Congress can check the courts. If they don't like a decision made by the Supreme Court, they can pass a constitutional amendment. A good example of that was the amendment to allow 18-year-olds the right to vote. The Supreme Court had originally struck down the law that allowed 18-year-olds to vote in federal elections. So the Supreme Court struck down that law, and so Congress passed an actual constitutional amendment, the 26th Amendment. So the courts can be checked by Congress through constitutional amendments, or they can rewrite the laws to fit the way the court wants them to fit. Public opinion can also play a role in what the judges rule. They tend to look and see what public opinion is. They're not going to make a decision that all the Americans won't be able to live with, okay? And so they also have to keep in mind the court really doesn't have a way to implement the changes, so they have to rely on the president's cooperation and Congress's cooperation. And since those two bodies are closely tied to public opinion, you can see where sometimes the court kind of looks at public opinion because they're political creatures too, just like our elected officials. They keep what the public wants in mind when making these decisions, okay? And so real quickly here as we finish up our lecture on slide number 35. Our courts in the United States do not make hypothetical judgments, okay? They don't make decisions, well, what if this happens? They don't do that. They only decide on cases that are brought before it. So in order to get the court's ruling, you actually have to bring a lawsuit to the courts before they will actually ruling. They don't make hypothetical rulings, okay? Alrighty, well that's all for our lesson on the courts. And don't forget to take the quiz on Congress. Have a good day. Thanks.